right, Dave in Sacramento, California. Dave.
Hey, Brad. Thanks for everything that you're doing. I have 2 questions for you. Can you hear me?
I hear you loud and clear. Excuse me. The water went down the wrong throat, but I do hear you loud and clear. Okay,
so I came in this country in 2014. Since that, I was an asylum applicant. I overstayed on my visa. That was a B1 and B2. So I got arrested in 2019 for the first time. I got involved in the fight with my friend. But later on, he didn't file any charges against me.
Right.
So the case has been dismissed. And the second time I got arrested while my friends were visiting me from Canada. And, I really don't know the law of this country. And I hit the, fence and I left the scene. So, but later on, I apologized to the police station. I went there. I told them I didn't know the law.
Did any of these end up in convictions?
No, it was never. And in the conviction, the hit and run, they later docked.
Okay, and the first case, did it end up in a conviction?
No, it was dismissed. I never charged with that.
Okay, so you have 2 arrests and both were dismissed. When did you get your green card? When did you get your green card?
No, I did not have any green card, but right now I just got married with my wife. She's an American citizen, and I'm looking to file permanent resident through my wife.
Sure.
So my question is there any consequences for me if I apply to my wife now? Because
you should apply. There is no law that says if you're arrested, you can't get a green card. There is a law that says you have to show good moral character, and perhaps being arrested several times may go against your good moral character. But it sounds like both of these arrests were really silly, minor things. And I think that if you filed your adjustment, you would have probably a really, really, really excellent chance of being able to show you're a person of good moral character. That's only reason how these criminal cases could affect you. But both minor offenses. It's not like you got arrested for attempted murder and you got off, or you got arrested for sale of drugs and the charges were dismissed. Those would be much more serious offenses that I would be concerned about. But what you described to me is petty stuff. They were both dismissed. I would think that you would get your green card. Perhaps you would want to have a good lawyer, but hold on one second. Let's go to Jay in Rio de Janeiro, Brazil. Jay, how are you?
Hello, sir. Yeah, can you hear me well?
I hear you perfect.
Oh, good. Great. Okay, so let me just give you a very quick background prior to my question. So I'm a former green card holder for about 17 years in U.S. I'm a registered nurse in U.S., but I got a couple of misdemeanors. So, since after I broke up with my girlfriend, I put a no-contact order against her. Then 2 weeks, she put another no-contact order against me. It became mutual, and she decided to falsely accuse me of rape.
Right.
Now, it was dismissed, but I got an anti-harassment order violation and criminal trespass. And then finally, in 2015...
Right. So just so you know, a violation of an order of protection is an aggravated felony. So you got deported on that?
Well, here's the thing. In 2015, I requested voluntary departure.
Uh-huh.
So I suppose that's a good thing because it's not technically deportation, because in the 15, I had a no-contact order against my ex-wife, and just because I was 20 feet away from her at my daughter's high school graduation by accident with no intention, I was dumb enough to,
you had orders of protection from 2 different women.
Yes, and then yesterday, so I got voluntary departure back in 2016, and I did everything right. I've never been illegal for a second there. I'm a registered nurse in the U.S. So yesterday, I finally filed the DS 230, right? For a green card through my son.
Right.
And my lawyer told me, so I'm calling to get a second opinion from you, Brad. So my lawyer told me that in the explain section of the criminal part of the DS-230, he told me to just stick to the basics of the charges and convictions, because he said the immigration officer, they're just worried about explaining just the bottom line, the charge and the conviction. And that at the interview, I should be able to have the chance to explain, how things got into place, like in the jail.
I would need to see the dispositions. If you have domestic violence offenses, that would prevent you from getting a green card. If you have multiple assault convictions, that would prevent you from getting a green card. I don't know what your criminal record looks like. And it's not about, you could explain everything till the cows come home. Your explanation at an interview actually is meaningless. It could only hurt you, not help you. It would hurt you if they're caught in a lie. It doesn't help you in any way. It's not like you can talk your way out of it. The disposition is the disposition. And in immigration, they go on, what were you found guilty of? Period. And you look at it from a legal point of view. You were found guilty of XYZ, of this particular law, in this particular state, and you got this particular sentence. And if you are found guilty of this law in this state, in this sentence, do we classify that as nothing? Do we classify that as a crime of moral turpitude? Do we classify that as an aggravated felony? Do we classify that as a domestic violence offense? And based on what you pled guilty to and what your sentence is, and they classify it. And it has nothing to do with what your explanation is. Your explanation is irrelevant. It's, what is this classified? Did you plead guilty? How is this classified? Now, they will ask you about all of these arrests because they're not your friend. They're looking to trip you up. They're looking to find you in a lie. They're looking to find out more information that they can use against you. Not to help you, against you. So when your lawyer says, you'll explain it away at the interview, what kind of BS is that? You're not explaining anything away. All you're doing is, by explaining it, is just opening yourself up for more problems. So you just answer the question as succinctly as you can. Now, if you're asking me, let me finish. If you're asking me, are you going to get through? I don't have the slightest idea, because I would need to see your criminal records. And then I would need to determine whether or not you have crimes of moral turpitude, aggravated felonies, domestic violence, or maybe you got nothing. If you are inadmissible, let me finish. If you are inadmissible and your son is filing for you, now you don't have an order of deportation because you took a voluntary departure. So you don't need a waiver for the deportation. But you could be found inadmissible based on these particular offenses that you pled guilty to. Let me finish. If you got deported as a result and you ended up having to take a voluntary departure and give up your green card, I would assume you're also inadmissible. So you can't get a waiver through your son for criminal activity unless all of this criminal activity took place more than 15 years ago. So if it was within the last 15 years, this lawyer having you file for your son is just spinning your wheels. You're going to go in. You've been found guilty of offenses that you ended up having to take a voluntary departure. So we know they would have ordered you deported had you fought out the case. So if they would have ordered you deported, most likely you're inadmissible to come back to the U.S. You can't get a waiver through your children. There is no waiver for crimes through your children. The only waiver is 15-year statute of limitations. It all happened more than 15 years ago, and that's assuming it's only crimes of moral turpitude. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.